Like I always say, don't think it can't be you.
Feel my faith rising. I'm crawling out the trenches, holding me. My life.
Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I posted a video a few weeks ago discussing how to get your copyrights back after you've assigned or licensed them away. If you haven't already, you should check out the video, How to Get Your IP Rights Back. Also, if you're unfamiliar how licensing or an assignment works, I have another video that you should check out titled, Should I Assign or License My IP? I'll link both in the description box below. But for this video, we're going to pick up where part 1 left off. So for today, I will explain the process for how to terminate a license or assignment of your copyrighted work. Let's get into it. First, let's talk about how to exercise your right to terminate the license or assignment. As an author, you must terminate your license or assignment by serving a written, signed notice of termination on the grantee, which is the person you granted the rights to, or their successor in interest, which could be their children if they've already passed on. You also have to properly file a copy of the notice of termination that you served on the grantee with the U.S. Copyright Office. So let's talk about what's considered a proper notice. The notice must be true, correct, complete, legible, and signed. The notice must also include a statement that contains the date on which the notice was served and the manner in which it was served, whether that was done in person, by mail, or by electronic means such as a fax or an email. The notice must state the date on which the termination goes into effect, which must be between the 35th and the 40th year from the date that the assignment or the license was granted. We'll talk about that a little bit more later. The notice must include a notice of termination cover sheet that's provided by the U.S. Copyright Office. I'll link a copy down below. The notice must be timely served, and you have to pay the appropriate filing fee. Okay, so now that we know the how, let's talk about the when you should serve the notice. You must serve the notice of termination no less than 2 years and no more than 10 years from the effective date of the termination. Let's make this real simple. Let's say you grant rights in a character that you created in 1999. 35 years later is the earliest date that you could terminate those rights that you granted away, which would be 2034. However, if you want to terminate those rights in 2034, you have to serve the notice of termination between 2024 and 2032, literally to the day. Otherwise, you lose your chance to terminate the rights for another 35 years. With that, the effective date of termination again has to be between the 35th and the 40th year. So you can state in your notice of termination that those rights that you granted end any time between 2034 and 2039. Does that make sense? Okay, let's keep going. The last thing I want to talk about is what happens once you terminate the rights. So upon termination, all rights that were granted revert back to the original owner, but only in the U.S. For any works outside of the U.S., the rights of the grantee do not change. Additionally, if there were derivative works that were created from the original copyright, the grantee still maintains rights in those derivatives, whether it's in the U.S. or abroad. However, the grantee no longer has the right to create new derivatives. So essentially, the grantee no longer has rights in the original copyrighted work within the U.S., and the grantee no longer has rights to create any derivative works, whether in the U.S. or abroad. So let's use a real-life example. Currently, there is an ongoing copyright infringement lawsuit against Paramount Pictures for the movie Top Gun. If you've seen the movie Top Gun or even Top Gun Maverick, let me know in the comments. As a Navy veteran myself, I absolutely enjoyed both movies immensely. But let me get back on track. In 1983, a man named Ehud Yoneh wrote an article in a magazine. Paramount Pictures obtained the rights to the magazine and allegedly created the movie Top Gun based on Yoneh's article. Yoneh's children sent a notice of termination to Paramount Pictures. And they are now claiming that the rights that were granted to Paramount Pictures terminated in 2020 and reverted back to the Yoneh family. Well, in 2022, Paramount Pictures released Top Gun Maverick, a sequel to Top Gun, which would be considered a derivative work. The Yonehs are now suing Paramount Pictures for copyright infringement. And Paramount Pictures is claiming that Top Gun Maverick was completed before the notice of termination was served. Y'all see how this works? Like I always say, don't think it can't be you. So let's pull it all together based on what I just told you. Once you terminate rights in the US, those rights revert back to the original copyright owner. But the grantee maintains rights in derivative works that existed prior to termination. So the implications of this Paramount Pictures lawsuit are that if the court finds that Paramount Pictures rights were terminated in 2020, then that means the Yonehs are the legal copyright owners of Top Gun Maverick, which made over $1 billion in the box office. And therefore, Paramount Pictures will likely be found guilty of copyright infringement. On the other hand, if the court believes Paramount Pictures and finds that the movie sequel was sufficiently completed prior to the termination in 2020, then Paramount Pictures will maintain its copyright in the sequel, but they cannot make a third movie without the Yoneh family's permission, and they no longer have rights in the original Top Gun movie. Isn't this good, y'all? I don't care what y'all say. This is top notch. The whole point of these termination rights is to give the original copyright owner a chance to renegotiate their deal, because hindsight is 2020 and you just never know how valuable your creativity will be. All right, we done. Let me know your thoughts in the comments. If you got this far, thank you for watching. As always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far.